Good afternoon, everyone, and welcome to this afternoon's coronavirus webinar presentation. My name is Kathy Purdy, and I'm a marketing manager here at Bond. Two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will address those as time permits throughout today's program. Also, once the webinar has ended, if you would take a moment to complete the brief survey, we would appreciate that. Our presenters and attorneys do look at your responses and appreciate your suggestions for future topics. So to get things started, I'm going to hand it over to Pete Jones in our Syracuse office.
Thank you, Kathy, and good afternoon, everyone. I guess it's Groundhog Day, and I'm pretty sure the groundhog is not going to be seeing its shadow, at least not in upstate New York with the snow. I think pretty much the whole corridor for all of our offices. We got a busy program, so we're going to get started today with Charlie Sullivan. Charlie's got some observations on leases and contracts and some of the things that may be facing you in these unique times with COVID. Charlie, take it away.
Thank you, Pete. Good afternoon, everybody. During COVID, we have seen an increasing number of parties to contracts generally, and those are both commercial contracts and leases, frankly, finding themselves in a position that they can't perform. They can't deliver whatever good or service was required of them under the contract. That creates problems both for the party that has to perform as well as the party expecting performance. And frankly, it has caused clients and lawyers to look at, little used contract provisions as well as little used principles of law that have sort of operated in the background for many, many years, really to look at those with a fresh set of eyes, to see how they apply. And obviously from the party that is expected to do something under a contract, the parties who is expected to perform, that can't, that party is seeking to assert these things as a defense to the contract. And then the party that needs the performance of the other side is seeking to overcome these defenses. So let me talk a little bit about what some of the defenses are generally. One, and many of you may have encountered this because this provision is in a lot of contracts. Again, it's old boilerplate that has existed for years. It's a so-called force majeure clause. And the general premise behind force majeure is that if there is an unexpected event, a triggering event, such as a severe weather event, commonly phrased as an act of God, that could provide a complete defense to a party's performance under the contract. New York courts have generally reviewed or viewed the concept of act of God very narrowly, meaning an unusual, extraordinary, or unprecedented event, often requiring that those losses and injuries that are occasioned exclusively by natural causes, such as could not have been prevented by human care, skill, and foresight. So New York courts have a very narrow and restrictive view of this. Right now, we're finding that pandemic-related litigation over contracts and leases is really unfolding. There are very few reported decisions in New York that have applied force majeure clauses or any other type of defense. And so we're watching those cases unfold, but we can see some guidance emerging from them. The other common defense that can be raised is the defense of impossibility. That generally excuses performance where it has become objectively impossible for a party to perform. An example of that might be if a person were to contract with a builder to build a house on the coast, and then a weather event occurs that causes that strip of land to be washed away. That could either be force majeure or impossibility, because it's impossible to build that house at that particular location. Again, this is an old common law principle, which has been out there for a very long time, and it's being applied in a new context. As I indicated, there's very little guidance in New York. There are a number of cases that are starting to wend their way through the courts at this point, but we don't have any definitive guidance from those courts. There is some guidance in a commercial leasing context, which I think may be applicable generally. There was a decision rendered by the New York State Supreme Court in New York County in late last year, on December 21, 2020, that did give a commercial tenant in the context of a commercial lease some relief. This was a restaurant owner who was operating in a space in New York City. The landlord had sought to evict on the basis of non-payment of rent after having applied the security deposit for outstanding rent early in the pandemic. The tenant moved for an injunction prohibiting the landlord from evicting the tenant. Again, arguing all of the grounds that I had talked about earlier, and the court did grant a TRO, which blocked the landlord from actually taking steps to evict the tenant. And the court hung its hat on language in the lease, which excused payment of rent in the event of fire or other casualty, finding that there was at least a preliminary showing that the pandemic might be a so-called other casualty that would excuse the obligation to pay rent. Again, the court at this point has not rendered a final decision in the case. This is just a decision on granting a temporary restraining order. But I think it may give some indication of how New York courts will view this as these decisions ultimately are made. I think there will be some forgiveness given to parties who are unable to perform. And we just have to wait for those decisions. For those of us who are drafting contracts or leases at this point, I think it's important that we, again, learn from this with this fresh set of eyes and specifically address pandemics and potential shutdowns from the government as a result of the pandemic, build that right into our contract provisions. And so we are now, for example, in a force majeure clause, expressly including that as an event that would trigger that relief. So again, this is something that we'll have to keep everyone up to date on as these cases wend their way through the courts, and we'll be watching that closely. Pete?
Charlie, thanks. Appreciate that update. I mean, there's a lot to keep our eye on there. We're going to move on now. We're going to talk a little bit about, Mara's going to give us an update on litigation in New York State. There's some new New York State court rules, and they're generally applicable to all manner of employers and businesses. So we thought we'd give you a brief update on this. Not strictly COVID related, but worth keeping our eye on. Mara, take it away.
Thanks, Pete, and thanks for having me. I just wanted to take a little time to update everyone, as Pete mentioned, on these newly passed rules. So an administrative order was passed in late December by the Administrative Board of New York Courts, which adopts a broad set of amendments to the uniform civil rules for the Supreme and County Courts in New York State. So these administrative orders are not uncommon. They're passed frequently, but this one in particular is notable because it's expected to have a pretty significant impact on the way that litigation matters move through the New York State court system. So it went into effect actually yesterday, and it impacts any litigation matters that are pending now in the New York State and County courts, as well as cases that will be filed moving forward. So the amended rules themselves are not new, so to speak, but rather they're being adopted from the existing rules of the commercial division. So for those who may not be as familiar with what the commercial division is, it's essentially a subpart of the New York State Supreme Court system. It was created in 1993 to deal with sort of more larger, complex commercial cases, such as breach of contract, business torts, and such. So over time, in 2006, the commercial division actually started adopting its own body of rules that much more closely reflects the federal procedural rules. And so they slowly have added more and more to that body of rules. And the Supreme Court and county courts, through this administrative orders, will be adopting 29 of those pre-existing rules, either in part or in whole. And so again, what it means in practical terms is that, as some of you may also be familiar with, the federal court cases tend to move much more quickly through the litigation process than state court cases typically have. In New York, the judges are less likely in federal court to grant extensions and adjournments, and discovery orders and scheduling orders are much more strictly followed. So we're going to expect to see that reflected also in the New York State. So Pete also mentioned the COVID impact here, and I will note that Chief Judge DiFiore, in announcing these rules, noted that a number of the changes also serve the goal, and this is her words, of limiting unnecessary personal appearances and foot traffic in the courthouses. And in the AO itself, so in the administrative order, the body of it, before it gives the rules, it kind of gives a summary of the purpose and background, and it notes specifically that recognizing the COVID-19 pandemic has created a unique opportunity for permanent reform. So essentially, the courts are already shifting and changing some of their procedural rules because of COVID-19. And so what they're noting is that this is something that's been in the works. They've been looking to adopt and make some of these changes for quite a while. And they've had some of working groups looking at adopting some of these rules from as far back as 2018. But she's noting that this time is actually one of the reasons that they are choosing to do it now is because of those already pre-existing shifts due to the pandemic. And so we can't obviously go through the rules themselves. There's many of them, and they're quite detailed, some of them. But I will just note that they essentially, some of the significant ones are limiting the number and duration of depositions and interrogatories, very similar again to federal court practice, requiring a lot more pre-conference consultations with counsel, so trying in good faith to resolve disputes on their own without involving the courts. Procedures for also not only discovery, disputes, and resolution, but also adhering to those discovery schedules, as I noted. And so we're really going to see the impact of how these this changes the way that New York State litigation really operates. Now, anyone familiar with New York State practice already knows that there's a lot of sources of procedural rules, from the CPLR to the uniform rules, specific court rules, individual rules of the judges. And this year, obviously, also the governor's administrative or executive orders, which I know that some of those have been discussed here in the webinars, and also some prior administrative orders, as I noted. That are specifically geared towards procedural rules during COVID. So as New York State procedural guru Siegel put it, even before these COVID rules, the various sources of rules lurking in all sorts of places in New York can create a minefield, even for the seasoned practitioner. So it is tricky to make sure that you're checking all these sources of rules before moving forward with filing papers or scheduling court conferences. So another thing that makes it a little tricky is that many of these rules actually use the word should rather than must and encourage judges to implement individual rules. So I think what we're probably going to see, based on experience in the courts and talking with other lawyers about this, is that you're always going to have sort of your old school judges, your more tech savvy judges. And so you're going to see some judges really excited about these rules and applying them more strictly, while as others maybe a little bit more hesitant to, not as comfortable with some of the technology. And so there's probably going to be, like there is now, a mixed bag on how they're implemented. So just a few best practices, and then we'll wrap this up. So despite the discretionary implementation, assume that all rules will be strictly applied. The administrative order reflects that there's no longer going to be an acceptance of litigation in cases lingering in the state court system, and judges are going to be a lot less tolerant of requests for adjournments and extensions, or allowing cases to generally drag on as they have in New York. So it means that state and court practice is going to start to look a lot more like the commercial division and like federal court practice. And just to note too, remember that these rules are being adopted by the Supreme and County Court rules, not city, town, and village courts, not family courts or surrogates courts. So with that, I will turn it back to you, Pete.
Thanks, Mara. I think, of interest to me is kind of the, I guess we call it the iterative approach, that state court is kind of moving the direction of federal court, but given the discretionary nature and, probably the comfort level of some judges, it'll be a while before we get there fully. Okay, let's turn now to Pat Melfi. Pat's here in our Syracuse office. OSHA issued some interesting guidance last Friday, and Pat's going to unpack it for us.
Thanks, Pete. The OSHA guidance that came out was probably in response to the Biden administration's hope to have the agency have a greater role in enforcement. What's important to note about what came out on Friday is that the agency made it clear that it was not creating any new legal standard, and that these were just advisory recommendations in informational in nature. Another threshold issue is that none of what the agency put out on Friday applies to the healthcare setting. OSHA has had a lot of agency information go directly to healthcare, and I think they wanted to make a point of these generalities not applying or superseding what they've done in the healthcare setting. As you would expect, this guidance has a heavy emphasis on face coverings and social distancing, and a lot of what the CDC has already put out. It also has an equally high emphasis on isolating and quarantining suspected or confirmed cases. There are some unique features of this guidance that are worth pointing out. One thing the agency recommended was the assignment of a dedicated workplace coordinator to field questions from employees about COVID. There's numerous points where the agency wants non-English speaking workers to have any COVID policies or practices translated into their primary language. And they want that education piece, or they recommend that education piece be tracked, knowing that which employees learned of it and when. The guidance points employers to incorporating the CDC's guidance on sanitation. The guidance wants an anonymous process for employees to be able to make complaints about COVID, and a greater protection against any form of retaliation for those that either make an anonymous complaint or complain directly to their superiors. One thing that you'll see is that the agency said that they would like employers to make vaccines available at no cost. Again, this is an advisory or informational recommendation. It is not a legal requirement that employers pay for the vaccine. The guidance ends with not distinguishing between employees who have been vaccinated and those who have not been vaccinated. At present, there's no scientific evidence that being vaccinated prevents transmission. So as the vaccines roll out and more employees get vaccinated, OSHA still wants them to do social distancing and the face coverings and comply with the remaining OSHA protocols. What I found most interesting about what came out on Friday was what OSHA went to on ventilation systems. There is some specific guidance given to, in the white collar settings, building and ventilation. The first two are generally unhelpful to us right now, because OSHA said that we should increase outdoor air and open our windows as much as possible, and then use fans when we open the windows. So that's not going to work in the winter. The agency admitted it's not going to work in the winter, but they went through some other very specific recommendations for HVAC systems. They recommend disabling any demand-controlled ventilation system. And that means that if you have a more recent ventilation or HVAC system that distributes ventilation based on capacity, agency recommends disabling that so that air is recirculated and exchanged in the building more frequently. They also suggest using air filters that are rated at MERV 13 or above. Now, what MERV means is a minimum efficiency reporting value or higher. That rating goes from 1 to 20. 13 is in the higher end, and it could be an expense to upgrade to that type of filter if your system even has the ability to use MERV rated filters. They also recommend keeping the ventilation systems running 24/7. So I know in our building, the air conditioning and the heat shuts off at about 6. The agency here is recommending that it run all day. Obviously, there's a cost to that. The last piece on ventilation systems are the use of ultraviolet germicidal irradiation systems. These can be installed. They're light systems that can be installed in HVAC heating ducts. Now, what I've just described, a lot of that is going to be very expensive. And when and if the agency ever comes out with an emergency temporary standard, it will be interesting to know if any of the ventilation recommendations that are made in this guidance make it to that emergency temporary standard. That is one promise the Biden administration has wanted employers to know is coming, which is an OSHA or a COVID-specific OSHA standard. I'm not sure right now if any of these ventilation recommendations will move into the enforcement aspect of the agency. That's something to keep an eye on and to look for. I can tell you that the agency's questionnaire for employers who have received a complaint does not have any questions about MERV 13 filters or disabling your DCRs. It really focuses on what a lot of the policies and procedures focus on, which is risk assessment and basically removing anybody who's suspected or confirmed case from the workforce. I do not know if the ventilation recommendations will become permanent or will become part of enforcement. That's something we'll be monitoring. I can tell you Cal OSHA, which is the state equivalent of the federal OSHA in California, has issued an emergency temporary standard for COVID. These ventilation requirements have not made it into Cal OSHA's emergency temporary standard. So it's something to keep an eye on. I find them interesting because when and if incorporated and based on the size of the building, some of these will be expensive. Now, obviously, there's going to be involvement of building managers in this to the extent any of these are feasible. But that is what I found to be probably the most notable part of what came out on Friday.
So Pat, before I let you go here, I got to ask you one question that is maybe a little unfair, but what to make of all this? Can you? I know that we have the general duty clause, and so we've got guidance. It's not regulation. It's some insight into what OSHA's thinking. But I mean, these recommendations versus requirements. How do we manage all this? I assume they are things that people could look at aspirationally. You're not going to get cited if you don't have it, at least not today. What are you thinking along these lines?
I think, I've seen numerous of the questionnaires. The process is an employee will complain to OSHA about a COVID concern. The agency will send that employer a letter saying, please answer these 18 to 20 questions. There you can see what their current enforcement, priorities are. The first thing is they'd want to see a written risk assessment or a written COVID prevention plan. If you have that, they would also like to see that you've distributed that and trained the employees on it. And then they want to know specifically your engineering or administrative controls to prevent exposure. Those are their priorities. And I think those are for everybody on this would be the enforcement priorities, the things that the must-haves in the world. The other thing that you will see in the agency guidance is, are there any employers out there who are requiring employees to work near or with suspected or confirmed cases? it's a major red flag to the agency. That's 3 questions in the questionnaire right now go to that. So I think, as a priority, written hazard communication or written risk assessment plan, demonstrating how that was flowed down to the employees, how we have told employees to comply with our COVID protocols, and then showing that you're enforcing whatever administrative or engineering controls. I'd focus on that at present. Putting the entire guidance into force right now, you might lose sight of some of the bigger picture items that I've just described. You might spend an awful lot of time spinning wheels about HVAC. But I think, to answer your question, I think those are the real big ticket items.
Great. Okay, thank you. That's very helpful. We're going to turn now to Katie Anderson in Albany with her weekly update on, what's going on from Albany. Katie.
All right. Thanks, Pete. Appreciate it. Welcome to everyone. So today we've always got news. So get ready. It's action packed. First up, I've been looking at this chart every week for you. We see that there have been some significant improvements. Cases continue to drop steadily. And now we are at the point where hospitalizations and deaths are thankfully decreasing. That's all good news. We will continue to be monitoring the situation. And, I think that hopefully this trend will continue of continuing downward. Hopefully we won't see another spike. There's also more good news on the vaccine front. I'm sure everybody's seen lots of news about vaccine trials and looking exactly at the percentages of how effective they are, right? Johnson & Johnson's came out this week, and there's numbers floating around that says, it's 66% effective. That's not the full story. The full story is that all vaccines that have been developed at this point, that are likely going to be on the market, their long-term efficacy is 100%. They prevent hospitalizations. They prevent death. People may still come down with COVID, but it will be a significantly less severe version of COVID-19 than we've been seeing for the past year. Why is that a good news? Because it shouldn't necessarily matter to you then which vaccine specifically you'll be getting. After 28 days, you will have the protection that you want. You will have that full protection. That's great news. And it's a messaging issue that has been going on. Dr. Fauci has been talking about it this week. The messaging behind this has been wrong. These are incredibly effective vaccines, and we should be looking forward to getting them. The Johnson & Johnson vaccine, we're hoping, will be authorized in the next 2 weeks in the US. That would be great because it's one dose and you don't need to refrigerate it to the extent that you need to refrigerate the Pfizer and Moderna. Novavax, same thing. We're hoping that that's going to be something that we can see. Worldwide, we've had over 100 million doses administered. The US, we've seen 32.8 million. And for New York, we've seen 1.9 million doses administered in New York. Great news. We will continue to be hopefully willing to have people stick out their arms for the cause and willing to get the vaccine. Testing update. This is also good news as well. The federal government has awarded a multi-million-dollar huge contract to Ellume, who produces at-home COVID-19 test kits. This is what's going to be underpinning a lot of the reopening strategy going forward. They will open a factory that's going to produce over 500,000 tests. 500,000 tests a day. And it's supposed to be easy. There are obviously concerns with this test. Each test will be about $30, so that could price people out. It also requires that you have a smartphone. That obviously will impact people who don't have smartphones. But this is good news. It shows that we're making progress towards getting at-home rapid testing just to make it way easier for people going forward. Microclusters, I haven't talked about them in a while, but I will now. last week we saw the governor get rid of everything but 5 of them. The Bronx has 2, Manhattan, Queens, and Newburgh. Those 5 zones remain. They are yellow zones. Remember, if you were in a cluster zone and you are now gone, I know you've been in that cluster for a long time. Some of you, the people in Elmira, you've been in one since October, but once you leave, the regular COVID rules apply again. What does that mean? Gatherings, you're limited to 50 people in, and it's, that's both indoor and outdoor gatherings. Indoor and outdoor dining don't have the restrictions regarding the number of people at a table. That is different for New York City. New York City, indoor dining may resume on February 14th at 25% capacity. Statewide, we're looking at wedding receptions now. Wedding receptions may open up for up to 150 people or 50% of the receptions venue's capacity, whichever one's smaller. Those may begin on March 15th. All guests have to be tested for COVID-19 beforehand. So if you're going to be having a wedding reception coming up, just know that that cost is going to be in there. Looking at a bill that was signed this week by the governor, this is also a good news bill. It's a little complicated, so I will just explain it the most basic way that I can. Basically, the legislation prohibits for 1 year any increases to an employer's experience-rated tax rate for your unemployment insurance because of workforce reductions due to COVID-19. What does that mean? The state cannot change an employer's experience rating, which goes into how much more you have to pay for unemployment insurance because of COVID-19 layoffs. This is good news. It means that hopefully there won't be huge fluctuations in what you're paying for unemployment insurance. With that, Pete, I'm done.
Okay, thank you. We're going to turn now to Paul Bueller. Paul's in our Albany office as well, and Paul's got a very interesting update on unemployment insurance, a handful of things to discuss.
Thanks, Pete. So following up, I know Katie gave you guys some good news just now. I have some good news for everybody as well. About 2 weeks ago, the New York State Department of Labor issued an order. We've been kind of parsing through, trying to understand what it means. And basically what they've said is they're going to look back at all the unemployment benefit charges that have been paid out dating all the way back to March 9th of 2020. And they're basically canceling them as against everyone's employer account. So that means that all of you guys that have, participate in the traditional unemployment insurance program, pay UI taxes, and have an experience rating, all of those claims that you've seen, whether they're related to the pandemic or not, all of the claims you've seen since March 9th of 2020, not going to impact your experience rating, will not drive up your unemployment insurance taxes. For those of you that are self-insured nonprofits, you were already getting a 50% credit from the CARES Act. Basically, New York State is going to come in and pay the other 50%. Obviously, self-insured nonprofits, you guys were getting this 50% reimbursement through the CARES Act. We don't know kind of process and procedure, what that's going to look like. We also don't know what this other 50% being chipped in by New York State is going to look like, but we kind of suspect that it will take the form of a credit against your future charges. I strongly suspect that New York State isn't going to be dishing out checks to all of you self-insured nonprofits that have effectively now overpaid all of your unemployment charges dating back to March. The other thing to note here, the Commissioner of Labor has said that this is going to keep going as long as the pandemic keeps going and basically until further notice. So as you continue to incur unemployment charges and things like that, again, they're not going to be charged against the individual employers. They are going to go to New York State's general account. Again, will not drive up your unemployment insurance taxes and will not be charged back to you self-insured nonprofits. The normal process and procedure for contesting charges, contesting, fraudulent charges and that stuff all still happen. So you should still get your monthly benefit statements, letting you know who is receiving unemployment insurance benefits, so that if you believe someone is not entitled, you can still contest. You can still alert the fraud division that, if we've seen certainly an uptick in fraudulent claims, where basically people who are still working, other people are coming in and filing claims in their name, trying to divert the money to themselves. So if that's happening, absolutely, you'll still be able to report that to the Department of Labor and have those charges removed. But whether the Department of Labor removes them or not, again, will not drive up your costs until further notice. Basically, we're going to wait and see how long DOL can continue to do this. And then the other thing I just wanted to mention, we've seen there is a brief, there's some changes in the New York State budget, the proposed budget, that will touch on unemployment, and I can certainly touch back with you guys if and when those become final. So that's all I've got, Pete. Short and sweet. Hopefully good news for everyone.
Thank you, Paul. Oh, I did it. Sorry about that. Thanks, Paul. The other thing I just wanted to mention was we've seen quite a few fraud claims recently. I think we've had a little bit of experience dealing with those. Could you just give us about 20 seconds on that, what the DOL is doing with those?
Yeah, absolutely. So what we've seen a lot of is that, like I said, a lot of people who are still working, if someone is able to find your social security number, they can file a claim, and they've attempted to divert that money elsewhere, whether it's the debit cards that they pay out for unemployment insurance benefits, or a direct deposit check, whatever it happens to be. What we've had a lot of success doing is basically alerting the Department of Labor that these employees are still working, these claims are not being filed by those individuals, and they've been very, very willing to cancel those charges and stop paying them out. So if that's happening to you, absolutely reach out to us, reach out to the fraud division of the Department of Labor. Hopefully we can get that sorted out.
Great, thank you. Okay, we're going to wrap up today with Jane Sovereign. Jane is in our New York City office, and we thought it'd be helpful to do a little bit on discipline for off-duty conduct. There's a potential for this more recently with active political demonstrations and other outside of work behavior. So Jane's going to take us through that.
Great, thank you. Thank you, Pete, and good morning. So we're certainly, as Pete said, we are certainly seeing off-duty conduct of employees that is coming to the attention of you, the employers. And there are a variety of ways, of course, of hearing about this. Social media postings, news reports, complaints or petitions from your employees or clients, or law enforcement coming to you, or the employee coming directly. Once you hear about this, how do you respond? Next slide, please, Kathy. One of the biggest takeaways I hope you get from this short presentation is that there is no one size fits all when it comes to dealing with off-duty conduct. The situations will be highly fact specific. The biggest factors are what the conduct is and the job duties of the employee, as well as the mission and culture and policies of your organization. You're going to be doing individualized determinations. And this presentation is not going to be a detailed how-to. It's really going to be a quick overview, alerting you to how to approach this and what are some of the relevant issues to look for. Next slide, please. So you've got a number of threshold questions, most of which are somewhat easy. Are you a public or a private employer? Are you unionized or non-unionized? What's the mission and culture of your organization? What are you about? And then identifying relevant policies. Of course, a collective bargaining agreement is key, or a discipline policy, but many, many others may be relevant. Keep your eye on the fact that we're in this time of remote work. So when are folks working? When are they on duty and when are they off duty? That's an interesting issue to consider. Next slide, please. An investigation is key, it's critical, and it will need to be careful and prompt and fair. If you are using an internal person to do the investigation, make sure you use someone who doesn't have an axe to grind, who doesn't have a problem with the person who's being investigated, or there isn't some relationship between family members and so forth. That can be overlooked sometimes. You'll be looking at the employee's role, of course. You'll be looking at, was the conduct actually off duty? Because if it's on duty, it's a much easier determination, obviously, and you have much more control. You'll be needing to see the evidence of the employee's actions. And as we all know, social media is shockingly, I know, not always true. So important to be very careful about checking records, your records, and not just taking certain things at face value. Next slide, please. You'll need to ask whether the activity, the off-duty activity, is protected by law or otherwise. And I will get into some of the particulars of that as we move along. The key question here, and this is really one of the other big takeaways, is the key question is whether the conduct off-duty is reasonably related to the employee's duties and or the functioning of your business, your enterprise. If you do end up making a determination that there was misconduct that can be disciplined, then you'll need to determine whether your proposed discipline is proportionate and whether it could possibly be discriminatory. Next slide, please. We're going to go very quickly through some of these related laws. I just want you to be able to spot these issues if they arise. New York Labor Law 201D, the off-duty conduct law. So employers cannot discharge or take action against or discriminate against employees because of specific off-duty activity, political activities, the legal use of consumable products, or legal recreational activities. All are carefully defined, fairly narrowly. This law applies to all employers, public, private, unionized, non-unionized. So you've got to pay attention to this should you encounter off-duty conduct. Next slide, please. In addition to having to figure out, is the off-duty conduct covered by the law, then you have a laundry list of exceptions. I'm not going to go through these now, we don't have time, but there are a number of very detailed exceptions. So this is a thought process that you will need to go through. Again, you may want to consult counsel on these, whether you're in-house counsel, your bond counsel, or other outside counsel. These can be very complex and nuanced decisions and analyses. Next slide, please. You'll also need to make sure you're considering late NLRA rights. And as we heard, both as we've been hearing at these webinars, in a number of agencies, particularly the NLRB and OSHA, the new administration is taking a much more employee-friendly approach. So you take what I say today and consider that it is going to continue to become more employee-friendly. So employees have the right to exercise protected concerted activity that can include a variety of protests and speech or petitioning, a number of things. And that applies, this rule applies to all employers and employment agencies. Next slide, please. Another section of the NLRA prohibits employers from taking action against employees for such activity. That when it could reasonably have a chilling effect on these rights. So This is a growing area. I will just mention that recently in December, the NLRB said that Google had wrongly fired 2 employees that Google claimed were violating rules in their off-duty conduct and sneaking around and looking at things they shouldn't have been. But the NLRB said no, they were trying to create momentum among their colleagues to protest various policies of Google. So this is something you'll need to keep an eye on. Next slide, please. Related to, if you are, the off-duty conduct is the subject of criminal allegations or an arrest or a conviction, keep in mind the laws that you already know, the New York State and, if applicable, New York City laws about conviction and arrest records. Now, I won't go in great detail to this, but as you know, if you're looking at any prior convictions or arrests, there's a very specific thought process and analysis that needs to be done as to whether the employer can even consider these. The off-duty conduct law provides that if someone's off-duty conduct is illegal, it's not protected. That might mean that the employer has to prove it's illegal, or might mean that it's the subject of a pending arrest. That is currently these laws on conviction and arrest records don't protect employees with respect to pending arrests, but that will change in New York City. There's been an amendment to the New York City Fair Chance Act that pending matters will be covered by the act effective July of this year. So keep that in mind as well, that these are laws that are important if it as relates to law enforcement activity, and you will need to pay attention. Next slide, please. So you're at the question of what is the nexus between the conduct and the employee's job and the employer's business. If you do decide that you are going to discipline, you'll need to think about, is the discipline proportionate? You'll need to look at, are there others who are similarly situated, similar or somewhat similar activity, and how were they treated? Does the punishment fit the conduct? And could there be an argument of discrimination that, say, employees who are white were treated one way and employees who are Black are treated another way, or that, any other characteristic, you'll need to be mindful of that. Next slide, please. And then additional steps, just to keep in mind, discipline is not necessarily the be all and end all, nor really truly the end of these issues. Your workforce is particularly if these have become widely public, your employees are very interested and concerned about how you're going to respond. So keep in mind that there may be appropriate responses to your workforce, particularly if folks brought a complaint or petition. They should be responded to, even if it's difficult. And it may be appropriate to acknowledge and meet with others in the workforce who have particular concerns about the off-duty conduct for whatever reasons. It's always appropriate to express your organization's values. Even if you determine you can't discipline for the particular conduct, you can reiterate what you think of the conduct in some circumstances and what your values are. While it is very important to be sensitive and respond to groups that have brought issues to you, just a word of warning, be careful not to let individuals or groups take over and weaponize your complaint process to fight proxy wars and essentially be trying to get people or make political points. So be careful about how you allow people to use these and be mindful, of those issues. Next slide, please. So what can an employer do right now, if assuming you don't have an incident yet or nothing brewing? Simple advice, the same kind of advice that you have with other issues. Establish and maintain good HR practices and policies. Make sure your job descriptions are accurate and complete and up to date. Make sure you are periodically reviewing your policies and handbooks to make sure they're clear and current and effective. And most importantly, regularly remind and train your employees and managers about your key policies and why these policies and standards of behavior are important to your organization. The more you do those things, the better chance you will have of being able to enforce those policies and having people pay attention to them. Last slide, please. Again, these issues are very complex, highly fact-specific. Again, we encourage you to consult counsel, and also, if there's anything we can do if you have more detailed questions, please let us know. Thank you.
Jane, thanks. These are tough issues, especially because oftentimes you may get some publicity out of this. You'll inevitably have people saying, this is a free country. I've got the right to engage in free speech, even though that is, not unmitigated, certainly in the private context or even in the public context. But Jane, that's an excellent, kind of taking the emotion out of it and dealing with it step by step, piece by piece, walking it down through to figure out what values are implicated, what the appropriate response is. It's a real good approach.
Yeah, take a breath is really one of the first things that I should have put in the first slide. It's really easy when you hear of something very upsetting to just, off with her head, fire him, and take a breath, because it's, if you do your process right, you'll probably be able to get to a place that you're comfortable with. But if you don't do it right, you can end up with the worst of all worlds, which is trying to do the right thing, having it overturned, and having the person come back and everybody's unhappy. So yeah, absolutely right.
Good advice. Okay, well, thanks everybody for being with us today. We appreciate you attending today and every Tuesday. We'll be back here again next Tuesday. In the interim, please stay safe and stay warm. We'll talk to you soon.